It's almost good news. Okay. So this is a very important article here in Australia. And I'd just like to read it to you. So Greg Barnes, who is Julian's legal representative, one of them in Australia, has a lot to say here. We're not getting much information from the state, but Greg has just spoken out, and so he's given a lot of the information. So what we've had happen, and as you announced in the headlines, Australian diplomats have reportedly visited Julian Assange in Ecuador's embassy in London to hear firsthand about what his lawyer says is his deteriorating health. Greg Barnes, an Australian lawyer and advisor to Assange and WikiLeaks, revealed the visit had taken place. He said he and his colleagues will now directly appeal to Foreign Minister Marise Payne to petition the UK government to let Assange leave the embassy for urgent medical care without being arrested. Okay, so the Australian High Commission in London refused to comment on the visit, even to confirm it took place, referring all questions to the Department of Foreign Affairs in Canberra, a clear sign the situation is still a diplomatic quagmire. But Barnes said it was the second such visit. Well, we know about that because the first one was made very public. Took place in June last year. He said it was a sign of a more humane approach from the Australian government because I believe this visit was unsolicited. I haven't heard any mention that it was going to happen. So the visit came a day before Assange received the bad news from the US, where a federal judge refused to force the Justice Department to admit the existence of what are believed to be criminal charges laid against him in secret. So this is just a backstory about how long he's been there, Sweden having closed the investigation. However, Britain won't drop the arrest warrant for his failure to show for extradition to Sweden. It's going back a long time, and we wonder why, because the primary case has disappeared. But, you know, it's a hook with which to grab him when he walks out of that embassy. And that's why it's saying he cannot leave, the lawyers are saying he cannot leave the embassy due to the likelihood of being extradited to the US, where they say he would not receive a fair trial. And if you listen to the interview with Christine Assange from August 9th, she fully details the legal context of an asymmetrical extradition arrangement between the UK and the US. So the US really don't have to present a prima facie case to get someone extradited. It's pretty well just you know, an automatic process where it can happen very, very quickly. They have seen firsthand the untenable situation Julian is in. His health is deteriorating, yet he cannot get medical care for fear of arrest. It's really barbaric. Oh gosh. We will be asking Senator Payne to seek undertakings from the UK that Assange can leave the embassy for healthcare without being arrested. Barnes said Assange was in one arm and needs dental work. I do believe from John Pilger's speech, he was talking about the letter that Julian's father sent to our Prime Minister. And he said that Julian had a chronic cough for a very long time now, for years. And so he needs an X-ray. That's not something that can be seen from the outside, but I have certainly heard it hundreds of times. Julian does have a terrible cough. So we don't know what's wrong that could be something even more serious. But being in chronic pain from one's arm, that's a frozen shoulder to start with, but it's now sounding like it's the arm as well. And I did actually read that can be a symptom of vitamin D deficiency. He is ashen, though. That's something that various people have reported, that his skin was pure white, which is normal if you haven't seen the sun for going on 7 years now. We're going into the 7th year since the man hasn't seen the light of day, felt the grass under his feet, or the wind, or heard the birds, all those kinds of things that we feel a part of, we take for granted as everyday life. But this man is locked in a room virtually now because his access to various parts of the embassy has been restricted. So you have also this, so it's saying that his health continues to decline. On Wednesday, a US district judge refused a request from WikiLeaks to force the Justice Department to reveal a secret criminal charge against Assange. And we have the judge, Leonie Brinkema, who's talking about, oh, we can't move really when there's such uncertainty. What a joke. What a joke. Brinkema seems to be fairly consistent in her judgment. First of all, Kiriakou tells us that she reserves all of the these cases, whistleblowing cases, and now journalism cases for herself. And but it's just the terms of the antiquator, well, now exhumed and like a zombie, alive and kicking like a zombie, the 1917 Espionage Act, whereby, you know, compared to a criminal court, one can say the reasons why one committed a crime, and that could, you know, so if I murdered this person because they were holding a gun at my head, you know, then it could be considered self-defense. But there are no provisions to speak about motivation whatsoever. But I was just going to comment on the uncertainty principle. Just going back to a screen share to take a look at what Judge Brinkema said.
You want to
yes,
talk about?
Well, I'm just on my screen share at the moment, looking at Brinkema's own words. The settled rule that the court will not anticipate a question of constitutional law in advance of the necessity of deciding it. Petite versus United States, da-di-da. It requires that the committee's application be dismissed until there is sufficiently certain disclosure that charges have in fact been filed. The committee's common law and First Amendment claims are premature. To hold otherwise would mean that any member of the public or press, by demanding access to judicial records based on little more than speculation, could effectively force the government to admit or deny that charges had been filed. Permitting such fishing expeditions would require courts to sort through endless factual permutations, giving rise to varying degrees of uncertainty. Courts cannot perform the delicate balancing required by the First Amendment and common law doctrines under such uncertain circumstances.
So what does that say, Cathy? She's covering for the government. She's covering for the government that inadvertently told the world that he's been charged. And this is supposed to have an independent judiciary in the United States. It's supposed to be an independent.
But
I'd like to talk for a second, though, Joe, about charges that Julian may be facing. I think the conventional wisdom is probably right that the Justice Department is charging him with espionage or espionage-related crimes. In any other district in America, this would be ludicrous. It would be outrageous. And I'll tell you why. I was desperate to not go to prison after my arrest. And so I hired O.J. Simpson's jury consultant. He happened to be my best friend's wife's uncle. So he did it for nothing. He came up to DC. We went to the trouble of getting him a security clearance so that he could review my case. And he got it very quickly and went through 15,000 pages of discovery and then said to me, if we were in any other district in America, I'd say, we win this thing. It's easy. Hands down, we win it. But the Eastern District of Virginia, you don't have a prayer. Your jury is going to be made up of people from the CIA, the FBI, the Defense Department, Homeland Security, and intelligence community contractors. He said, you just don't have a prayer. Take a plea. That's why they charged Julian in the Eastern District of Virginia. No crime was committed in the Eastern District of Virginia or anywhere else for that matter. But they charged him there because they knew that the deck was stacked. And in any other district in America, people would see the truth, that the man's a journalist. He was simply disseminating information in the public good, and should not be prosecuted for that. That's the exercise of freedom of speech. But that's not how it's going to play out. Now, there are certainly more minor charges that could have been levied against him that he may have been able to, or still be able to negotiate, where you could maybe negotiate it down to a misdemeanor count of, let's say, failure to secure classified information, which is what General Petraeus got. But my real fear is they're not interested in a deal. They're interested only in coming down on him like a ton of bricks, and that's why it's in EDVA.
That's very troubling. In your case, did they invoke state secret privilege? I'm asking because this could also happen with Stone, maybe, if they try to challenge.
Absolutely, they did. In the very first hearing, they did. It's called an invocation of the SIPA Act, the Classified Information Protection Act. And so that meant several different things. It meant that that no one was allowed inside the courtroom unless they were cleared. So it was my attorneys and me, the prosecutors, the judge, the bailiff, and one clerk who took the classified transcript. And that was it. The door was physically locked, so nobody could come in. And then when they would declare it a SIPA hearing and throw everybody out and lock the door, they would then sweep the whole courtroom for bugs. And it was only then that we could begin talking. Now, they overdid that because there really was no relevant classified information in my case. And that was my argument from the beginning, was that it was all unclassified. Or if it was classified, it was improperly classified. And again, I fear they're going to do the same thing with Julian. Just say everything's classified, everything is a secret, it's all national security, when in fact it's not. Not at all.
You and your defense were allowed to remain present for that hearing? I thought that they kicked everybody out. Like in the Sibel Edmonds case, I think in Sibel Edmonds' case, she and her lawyers weren't even allowed to be there. Is that right?
That happened to me once, where we had asked for 70 documents to be declassified. So we had filed 70 separate motions. And I needed these 70 documents to defend myself. And so as soon as we went in, the prosecutors invoked SIPA, and then they asked for, it was called a Part C hearing or Part D hearing, something like that. I had never heard of it. And as soon as they said, request a Part D hearing, my lawyers jumped up simultaneously and said, objection. And I said, what's going on? And they told me, hold on a second, this is important. And so, so the judge said that she'll hear the prosecution in camera. And my lawyers objected again, and then said, at least let us come in without our client? And she said no, that it was in camera. So she goes into her chambers with only the prosecutors, and then she comes back out and she says, I'm going to save everybody a lot of time, and I'm going to reject all 70 of these motions. So I never had any idea why I was being denied the ability to defend myself. Whatever the decision was, it was classified, and neither my attorneys nor I had the right to know. And so here we are. That was 7 years ago, and I still don't know why my motions were denied. Julian's going to go through the same thing.
And the word leaks out that a grand jury exists, and then the Julian Assange and his legal team come in to ask the court to unseal the indictment so that Julian Assange in particular and his legal team can understand the indictment. And the judge says, well, the public's desire to understand what's happening is, quote, premature. Like, what does that mean? That's her words. It's a premature desire to learn the truth about a secret grand jury. So a secret grand jury is in existence, apparently. It inadvertently, through a court filing, is acknowledged to in fact exist. Julian Assange goes into court, and the judge rules, quote, courts cannot perform the delicate balancing required by the First Amendment and common law doctrines under such circumstances. And then by acknowledging if she were to unseal the indictment, she would be revealing that a grand jury in fact does exist, and the government has kept the grand jury secret. So then you must ask yourself, what's the point of having a court? What's the point of having a court if the judges feel so duty-bound to defend the national surveillance state, even as it commits and conducts itself in illegal ways? What's the point of having a court? I mean, it truly is a Kafkaesque nightmare whereby no one is entitled to learn the truth. And if you learn the truth and want it confirmed, your desire to learn the truth is, quote, premature. Because, of course, the secret keepers haven't made it publicly available information, but nor will they. That's the point of a secret grand jury proceeding. I mean, it's really, it makes one's head spin.
So I was just thinking that two things. I believe that there still is a second chance. And Joe, you can come in and verify this for me. There is a second chance to have the charges unsealed from the Inter-American Court of Human Rights, because that is one of the requests. And as far as I know, that is another attempt, isn't it? Or is it the same one to get the charges unsealed?
It's part of the petition that was filed by WikiLeaks to that Inter-American Commission on Human Rights, part of the American Organization, American States, to end Julian's isolation and to unseal that criminal complaint. But I have to tell you, being a student of American history and politics, they look upon international organizations as with disdain the moment they do something that Washington doesn't like. We've seen that with the International Court of Justice, which ordered the U.S. to stop mining the harbors of Managua during the civil war in Nicaragua in the 1980s. We see it all the time at the UN, where they don't get the resolution to invade Iraq, they invade Iraq anyway. So they use it as a way to sanction what they're going to do anyway. In fact, inside the Bush administration, just an aside, there were many who didn't even want to go to the UN. I think it was particularly Cheney, but it was Powell who forced them, and they didn't get the resolution, but it was totally immaterial to their aims. So even if this court tells Ecuador that, well, they would have to tell the U.S. to unseal this, U.S. being a member of the OAS. So the court has some jurisdiction over the U.S. They could tell them you must unseal this, and they will be laughed at. I guarantee that. They do not have legally binding or judgments. They could tell them the only thing that the members of the OAS are obliged to do is cooperate. So the U.S. would have to respond to a request, and that response would be no. And they have no enforcement mechanism. Nobody and no international organization has an enforcement mechanism except the Security Council. Even the International Criminal Court doesn't have a police force to arrest. They have to rely on governments to arrest someone who's been indicted as a war criminal at the ICC. So only the UN Security Council could impose sanctions and authorize war, which is what the US wanted in Iraq and didn't get, but didn't stop them. So I don't want to make light too much of what that I think it has a political significance, like a General Assembly resolution, which can embarrass governments, can show the will. So if the court decides to tell the U.S. unseal this, that should be news. It won't be reported. We'll certainly report at Consortium News. We'll discuss it on this Vigil. And it shows that an international organization ruled in favor of WikiLeaks. That's significant. But they cannot get it enforced or binding on the U.S. So this is a final decision by Brinkema.
But don't you find this weak and hypocritical? Goodness gracious, didn't Department of Justice go on a fishing expedition to Ecuador to question 6 Ecuadorian diplomats, except not Fidel Naves? He refused this kind of intimidation. But all that on the back of a crazy story with absolutely no evidence about Paul Manafort visiting Julian Assange. They're quite willing to move forward when there's that kind of uncertainty. They could say, well, this is an investigation, but, there's absolutely nothing there in terms of evidence. And of course, we have been trying, even Alan Rusbridger is urging Kate Viner to respond. But as I said last week, there's a possibility that, Luke Harding, who was in Ecuador, and the other journalist.
Money from the NED, yes, he was getting money from the
Yes. So, they'd been there for 4 months working with the NED on this story. So they probably had a fair idea in view of the fact that their Ecuador co-author in the print edition, whose name was Villavicencio, Fernando Villavicencio. So his name was removed, but it is well known that he has been an intermediary for the CIA. So there is a good chance that the long-term silence, which it's done a lot of damage to the Guardian's reputation, this one.
Well, it's interesting you said that about Rusbridger, because I walked up to him after an event at the National Press Club here in Washington. It was short. There's only a few days after this Harding story appeared, and I asked him about this, and he refused to comment. But now you're saying he's coming out and putting pressure on Viner.
Yes, well, there's a few points that were made there. Just the most recent one. Well, this also ties in with the mission of the Integrity Initiative,
right?
Institute of Statecraft,
absolutely,
baby. Because it has been reported that this, and we can see it, that this is essentially a pro-war scenario with all these different clusters, including in the United States, that are all putting out this anti-Russia stuff. And if you look at before Trump was elected, we were already quite worried that Hillary Clinton was going to provoke a situation in Syria that would start a war with Russia. So, it's just he's sort of in the way. He said, wouldn't it be nice if we got on with Russia? But it will be back to business. But I don't know if getting rid of Trump is the main event, because I feel that getting rid of the whistleblowers and getting rid of the journalists who print what they report is much more of the main event. It's the long-term event. And I feel that secrecy, this government secrecy, has been weaponized. Just getting back to the situation with the 6 diplomats who are being questioned about Manafort visiting Assange, we will never hear what they said. And I believe that this is nothing more than paranoia inducing intimidation. Julian could worry about that.
You know why?
What have they said? Because they fabricate.
Do you know why we won't hear about what those diplomats said, Kath?
Because it's subject to an investigation that is currently in progress.
Well, that's what they tell you, the BS stuff. Tell you, no, I think it's because they cannot confirm that Manafort had visited the embassy. If they did, we'd hear about it. Of course. Right?
Oh, possibly. We hear about so many things. There's been so many violations right from day one with Julian in Sweden. The police went to the press. And the story of, this was against their own laws.
In the middle of an investigation, they went to the press.
Yeah,
so that
absolutely.
Investigation is rubbish. Yeah.
I was listening to Edward Snowden for 3 hours last night. And, this is a real problem that the government don't want to have anybody. This is part of why you can't defend yourself as part of the Espionage Act. No questions asked. We have supreme authority, our narratives, and you are not allowed to challenge them.
Can you give us some insight from your own experience about how prosecutors can be extremely dishonest and deceptive to mislead the public?
Oh boy, there are literally no rules for prosecutors or for federal investigators. They can lie, they can deceive, they can cheat, they can do anything they want. And one thing that I kick myself for not reminding myself when it was happening to me is they always know the answer to the question before they ask it. And so where many of us get wrapped up is by trying to please them, trying to rack your brain to give them an honest answer, and then you end up misspeaking. That misspeaking can be used against you, of course, as a felony, making a false statement charge, or in some cases, an obstruction of justice charge. Just say, I don't recall. That's it. That's a legitimate response. I do not recall. When I had been arrested, I was charged, in addition to other things, with one count of making a false statement. I hadn't made any false statement, and of course that charge was dropped. But the prosecutors threatened me with another false statements charge and an obstruction of justice charge because I kept saying I don't recall. The honest to God's truth was that I didn't recall. And they were furious that I didn't give them an answer that they could then use against me. Well, that's one of the tricks that they have. That's the leverage that they have over you, because once you make that mistake, they immediately file a felony charge, and then they offer later on to trade it. Well, we'll drop these charges if you talk about so-and-so, or we'll drop all these other charges if you take a plea to a reduced charge. And that way they get a conviction, and that way they get a promotion, and they get a $400 performance award, and then they get to put your name on the ticker at the bottom of their website, and they all congratulate themselves. That's the system, the corrupt system that we have.
But what is the real problem here? I think that the real problem, and I'm just going to screen share again, because William Binney talked about Executive Order 13526, Section 1.7. So I went and dug that up just to have a look at exactly what it says. So let's share again. So for some reason, my Zoom window is always in front of what I want to read. But here we go. So Executive Order 13526, Section 1.7, it is illegal to classify information that would conceal a crime. Let's read the actual thing. In no case shall information be classified, continue to be maintained as classified, or fail to be declassified in order to conceal violations of law, inefficiency, or administrative error. Ha! We've had some administrative errors, but I mean, of late. Or two, to prevent embarrassment to a person, organization, or agency. And, you know, it was reported not long after Cablegate that, you know, most of it was embarrassment that was caused. So the problem is that, you know, this law, this is President Obama's 2009 executive order, and it is not being observed. That is the problem. And this is my article, by the way, that I just wrote yesterday. So if President Obama's 2009 Executive Order 13526, Section 1.7, were actually put into practice, not only would we have less need for organizations like WikiLeaks, the US could leave the 1917 Espionage Act buried in the ground rather than exhuming and adapting it to prosecute whistleblowers, and we shudder to think journalists. But that has to be the next step.
And you make a good point that in a trial, if there were one, in a national security trial, like Julian Assange would face in terms of classified information, he could not use this as a defense, I don't think. Well, he could not use a defense or a political, what his motives were. You cannot, as Dan Ellsberg said on one of these vigils when he got on the stand, he wanted to explain why he leaked Pentagon papers, and he couldn't say that. But perhaps they could bring this forward, that the classified documents that WikiLeaks has published all should not have been classified to begin with, or at least many of them, based on this executive order you just said. They should not have been classified because they were about crimes or embarrassment.
Well, that's the point. That is the point that William Binney and I recall Vivian Kubrick talking about it as well. But that just seems to be ignored. We do have a problem, Houston. We have a problem with crime being committed behind closed doors. So the poor WikiLeaks, organizations like WikiLeaks and Julian Assange and whistleblowers like Chelsea Manning and Edward Snowden just feel their civil responsibility to step up and reveal them. That's all they can do, so that we will vote differently. I mean, if that makes any difference. But there has to be a straightening out of this executive order, because, as I say, you know, if there were no crimes, then we wouldn't need martyrs like Julian Assange and Manning and Snowden.
Absolutely. Gareth, you want to add anything?
Well, what I was just thinking was that if that principle that has just been enunciated in the law that was passed or that was promulgated by President Obama, that was just shown on the screen, had been applied in the case of John Kiriakou, surely he would have been declared innocent, or there would be no case, because if there ever was a case that involved clear-cut crime, it would have been John Kiriakou's case, where he was being prosecuted.
And which president prosecuted John Kiriakou?
Obama.
The same one who issued that order.
Exactly. So there you are. I guess we're in a maze here, aren't we?
Yeah. Well, that's right. I mean, did he really mean it? There's a question that we should ask. You know, he made a lot of promises, Obama, and he went ahead and did quite the opposite. He prosecuted more whistleblowers, charged them with espionage than in all of recorded history. So what's going on there? I mean, it's so confusing.
So this was a hope and change executive order.
Well, I mean, of course, the real explanation for that is the phenomenon that we've seen over and over again in one administration after another, which is no matter which president comes, or which man is elected as president, he inevitably is confronted with a phalanx of powerful bureaucracies, national security bureaucracies, who are determined to get their way, and who, generally speaking, do get their way, although there are rare exceptions to that principle, to that generalization. That is indeed, you know, what happens with regard to a series of decisions having to do with wars. And of course, it does happen with regard to issues of whistleblowers, for sure.
Yeah, I've got one more screenshot that just came through from our elves, our fact-checking elves in the background. I'd just like to show you. This is a joke. This is a joke. You're going to laugh. Okay, here we go. Where's my Chrome? Here we go. Share. Okay, so apparently it is legal to lie to Congress. False Statements Accountability Act, FSAA, was sponsored by one-term freshman Senator William Martini, who later became a federal judge. It included a bizarre subsection that permits judges, attorneys, and parties to lie to Congress, to courts, and agencies without liability. There you go. Ninth Circuit Judge Susan P. Graber
is a congressional, legislative designation rather than a law.
Yeah.
A law, right? I mean, that doesn't suggest that it was already passed. I don't know.
Yeah, well, it does say here, learn about the 1996 law they passed while you were asleep to make sure that no one goes to jail. So, but that requires further looking into, which I will do.
Well, if this ever became law, then you could lie and not go to jail, and in Julian Assange's cases, you could tell the truth and go to jail.
Well, that's the same for everybody, isn't it? This is the great problem. How do we, the public, ever get the truth? I was saying one of my memes that if it is illegal to classify information that reveals that conceals crimes, but it is also illegal to publish information that reveals them. Crime wins in the end, doesn't it? I mean, that's why we're in such a terrible state of not knowing what the hell's going on, and things just being done by people who benefit from secrecy and impunity. And it's happening here in Australia as well, in particular with respect to refugees. And Julian is a refugee. It's appalling.
I think Joe was just going to say something. Go ahead.
No, I was going to say they have all their bases covered there. So when they want you to lie and get away with it, you can, and when you tell the truth, you can't. So
I'm working very hard through alternative social media to try and get people to think of those highly relevant comparisons, to think of Daniel Ellsberg and the Pentagon Papers. Under the current logic, Ellsberg should still be in jail. To think of Woodward and Bernstein and the Watergate break-ins. Woodward and Bernstein should be in jail. There's no reason why the Australian government shouldn't be fighting for Assange's return from his 8 years of temporary and increasingly dangerous asylum in the Ecuador embassy in London. I think a firm and assertive defence of Australia's citizens' consular rights, as in the case of other countries, Cambodia and Egypt, would actually work if the Australian government had the gumption to push this to the point where it needs to be pushed. There is a way out that I can see which requires a certain exercise of courage and decency on the part of an Australian government, whether this one or the next one, which is, I hope, coming very soon. And that is for the Australian government to, first of all, make aggressive representations in London to have Assange's jumping bail charge set aside, because the Swedish government has withdrawn all prosecution. So it wouldn't be beyond the capacity of the Australian High Commission in London, our embassy there, to prevail upon the British government to waive that or set it aside. The next step would be, and I don't want to sound like a John le Carré novel, but things happen, would be for the Australian High Commissioner to drive in his car to the Ecuador embassy to pick up Assange, to drive him under the High Commissioner's protection, possibly with a British police escort, straight to Heathrow Airport onto the tarmac, onto a waiting Australian Qantas plane, because we actually have a direct Qantas flight, the Australian national airline, from London to Perth without stops. And once Assange is on that plane, there is no way he could be touched by the Americans until he gets to Perth. It would then become an issue for the Australian government and the American government what to do with Assange. But I believe that no Australian government would dare to extradite Assange to the United States without a proper legal process, without a proper charge tested in an Australian court. If the Australian ambassador, High Commissioner, walked into the Ecuador embassy and walked out hand in hand with Assange and put him straight into an embassy car, I cannot see Assange being arrested if the Australian government had taken the legal steps beforehand of clearing it with the British government to say, look, this is ridiculous, we're going to take him home. Australia needs to reassert its belief, which we had in 1949 when we helped negotiate the UN Charter and the UN Security Council rules. We need to reaffirm our belief in multipolarity, in a concert of independent and sovereign nations who come together in the cause of international security. We have to get away from this idea of us and them, that we are the good guys and Russia and China are the bad guys. There are no good guys, there are no bad guys. There's simply a multipolar world in which Australia as a middle power has to navigate its way. I'm not saying we should be anti-American, of course not, or anti-British, but we need to rediscover our independence of outlook. We should be standing up for ourselves and making our own foreign policy choices.